Hello friends, welcome to Awdhesh Academy. Friends, we have earlier learned about government, governance, and also about the probity in governance. Today we are going to learn about good governance. That is, how a government can provide a good governance, what is the meaning of good governance, how do we know that the governance which is provided by our government is actually a good governance. So let's proceed with this topic. So first we are going to learn about good governance and also the ethical governance. Now, good governance is when the government of a country performs its functions efficiently, effectively, and for the good of citizens. The meaning of efficiently is that it should be done quickly. That means there should be efficiency, there should not be any delay. When we talk about effectively, it means that whatever is the goal of governance, that should be achieved. For example, if we want law and order to be achieved, then good law and order should be maintained. In the same way, the job of the tax department is to collect taxes. So whatever taxes are due, it is able to collect that taxes. That is what is the meaning of effectiveness. And finally, it should be good for the citizens. Ethical governance refers to the government where the officials follow the professional code of conduct and practice values like equality, justice, impartiality, and compassion. So the ethical governance is quite similar to the good governance because the government officers do follow all the ethical values. And only when the government officers follow the ethical values, they can provide good governance. And therefore, ethical governance is also good governance since ethics and goodness are akin to each other and they implement each other. So an ethical person and a good person are quite the same. In the same way, ethical governance and good governance are also quite close to each other. And therefore, good governance is an ethical governance also. So how do we know that the governance is a good governance? For this, the United Nations Development Programme, that is UNDP, prescribes 5 principles of good governance. And so we are going to learn about these 5 principles. And these 5 principles are legitimacy and voice, direction, performance, accountability, and fairness. So these are the 5 principles of good governance according to UNDP. Now within the legitimacy and voice, we have participation and consensus orientation. Then within direction, we have strategic vision. Within performance, we have responsiveness and effectiveness and efficiency. Within accountability, we have 2 components, that is accountability and transparency. Within fairness, we have 2 components, that is equity and rule of law. So let's discuss all these principles in detail. Now let us first talk about the first important principle, that is legitimacy and voice. That means the government which is heading the particular country should be legitimate. That means it should be elected by the people. People should consider it legitimate. It should not be autocratic. It should not be dictatorship. So the first principle is the principle of participation. What is the meaning of participation? That all men and women should have a voice in decision making, either directly or through legitimate intermediate institutions. That means whenever we take a decisions, all the human beings, all the citizens of that society, adults, they should have some role in the decision making. They can do it directly, for example, by taking their opinion, by having a consensus, or they can approach the institutions like, for example, the Panchayat Raj and all that, where they can elect the people and they will be able to participate in the decision making process. Now, such broad participation is built on freedom of association and speech as well as capacities to participate constructively. So the idea is that the people should be able to express their ideas clearly. So if suppose government is planning to do something which is not right, then the people should be able to voice their opinion. And if they support, they should be able to voice their opinion. So the people should participate in the decision making. They are not subjects. They should have actual role in the decision making. The second important principle in legitimacy and voice is consensus orientation. That means we should not try to always decide the case on the basis of majority, because suppressing the rights of minorities is also not the right thing. So we should ensure that even if everyone does not achieve what they want to the fullest, a common minimum can be achieved by everyone which will not be detrimental to anyone. So instead of trying to see that everybody achieve their objectives, which is nearly impossible, we must try to see that at least a common level of well-being can be ensured. So that is what we have to see, that instead of looking for a few, we should try to see that some benefits reaches to all people. We should try to create a consensus, try to see that as many people agree to a particular decision rather than disagreeing and going for just majority opinion. Now the good governance try to mediate differing interests to reach a broad consensus on what is best interest of the group. So we should try to see that all people's views are accommodated here, and all the policies and procedures are framed based on consensus as far as possible. That means the number should not decide, the power should not decide, the wealth should not decide the policies. We must decide the policy on the basis of consensus. The second important principle of a good governance is direction. That means we should have a strategic vision. What does it mean? Leaders and the public have a broad and long-term perspective on the good governance and human development. We must not think only about today. We must think about future. For example, education, infrastructure development, healthcare, then rational thinking, scientific temper. So we have to see that public as well as the leaders, they should have long-term vision as to what we want to achieve in next 5 years, 10 years, 20 years, 30 years, or like that. Then the leaders and the public should also have a sense as to what is needed for such development. So what steps we have to take today so that we can achieve such type of development in future. They also have understanding of the historical, cultural, and social complexities in which the perspective is grounded. Now, whenever we decide our perspective, we should see that it should be in accordance with our cultural values and social complexities. We cannot take a decision which is against that. For example, we should not go for the implementation of one language policy for the entire country, because that will not be suiting to our interests. So we have to look into the cultural and social context and also the historical context when we decide our long-term vision. The third important principle is performance. A government should perform its job, and performance should be a criteria. So how do we know that a government is performing? There are two criteria. One is responsiveness. That means the institutions and processes should serve all the stakeholders. They should be responsive. If suppose someone asks for some solutions, put up some problems, they should be able to respond well. If there is a natural calamity, if there is any issues, they should come forward and solve the problem. The second component of the performance is effectiveness and efficiency. That means the processes and institutions produce results that meet needs while making the best use of resources. We must try to see that minimum resources are used for maximum output. That is one meaning of efficiency. At the same time, we should be able to achieve our goals, meet our objective, and so it should be effective. So these are basically the two important principles within performance. Now let's go to the fourth important principle, that is accountability. Now, a government officers or the public servants should be accountable to multiple organizations. So accountability is very important, and accountability also includes transparency. So what is the meaning of accountability? Accountability means decision makers are accountable to the public as well as to the institutional stakeholders. So institutional stakeholders basically means you can have CAG, you can have CBI, we can have courts. All these are different institutions. They should be responsible to them. At the same time, they should be also responsible to the common public. The accountability can be internal as well as external. Internal means within the department we have internal audit system, we have vigilance, and we have a discipline, and we have our own assessment mechanism. So that way accountability is ensured. Externally means the institutions like CBI, CAG, CIC, courts, they ensure the external accountability. The second important principle within accountability is called transparency. Transparency basically means the free flow of information. That means whatever information is there with the government, that should be able to be accessed by the public. So RTI is one of the examples through which there should be free flow of information is maintained. The processes, institutions, and informations are directly accessible to those concerned with them. So we should try to have minimum secrecy. And the people who want to access those information, they should be able to access those information. And enough information is provided to understand and monitor them. So sufficient information should be available in the domain of public or to the concerned party so that they can see whether the government is doing their job properly or not. Now, the fifth important principle of good governance is fairness. As they say that justice is not to be done, but it is also seen to be done, in the same way, the government should be seen to be fair to all sections of the society. Within this, we have two components. One is called equity, other is called rule of law. So let's first talk about equity. Equity means the good governance assures an equitable society. That means the difference between the rich and poor, the difference between powerful and powerless should be minimum. As far as possible, the society should be equitable. All men and women have opportunities to improve or maintain their well-being. And these opportunities, like the opportunities of job, opportunities of education, that should be available to all sections of the society. That is the meaning of equity. So the second important principle within fairness is rule of law. Rule of law basically means that the country must be ruled by the laws of the land. As they say, however high you may be, but law is above you. That means nobody should be superior to law. So rule of law is a condition of laws enjoying primacy over every other power that rules. So law is above Prime Minister, law is above President, law is above District Collector, law is above SP. That is the basic meaning of rule of law. So for that, the legal framework should be fair and enforce impartially, particularly the laws of human rights. So what is most important is that all the laws must be enforced in the impartial manner, and the human rights should be given a primacy. Nobody's human rights should be violated. So friends, these are the different principles of good governance, and I hope that you got good understanding of the good governance. Thank you very much for watching this lesson. Friends, today we are going to learn about the Right to Information Act. We have heard about it. This is widely publicized. We keep on hearing about the news of RTI activists and how the information which has been brought through RTI has been able to expose corruption and many other irregularities in the government. So today we'll learn about RTI Act. So let us first understand what is the need of information, why the information is needed, and why this RTI has been brought. What was the provisions earlier? Before RTI was brought, we had an Official Secret Act 1923. This Secret Act was created in the pre-independence period, and it has actually prohibited parting of any information from the government setup to any other organization or to the public. So if you are a government officer and you share any information which is available in your record, then it was considered to be a criminal act and you can be punished very severely for that. And therefore, what was there in the government file, nobody knew except those officers who were dealing with the file. As a result, what happened that you can take any decision and you can be assured that nobody will know why you have taken the decision or even what decision has been taken. So over a period of time, what has happened that the government officers become almost like a dictator or almost like a sovereign authority, because nobody can question their decision. But we know in a democracy, it is the people who are the rulers. It is the people who are the king. It is the people who decides who should act in which way. They elect the representative who become the chief minister, ministers, or the prime minister. And it is widely said, in a democracy, government of the people, by the people, for the people. And unfortunately, in the earlier regime, that is pre-RTI regime, the public itself did not know what is going on in the government. So this was a very great lacuna in our country, and that is the reason that RTI Act was brought. We know that information is power, and therefore if you provide the information to the people, it empowers the people, and therefore it strengthens the democracy. Let me share you a quote which has been given by the third president of Kosovo, when he said, "Democracy must be built through open societies that share information. When there is information, there is enlightenment. When there is debate, there is solution. When there is no sharing of power, no rule of law, no accountability, there is abuse, corruption, subjugation, and indignation." And therefore, my friend, it's very important for us to have the information about how the government functions, why certain decisions are taken, and therefore a need of RTI was felt, or right to information was felt from quite some time. And let us now trace the journey of the RTI and the evolution of the Right to Information Act. India first enacted its Freedom to Information Act 2002, and that was the first attempt to provide the information to the public. However, this law could not be operationalized because of the infrastructure requirement. Thereafter, in the year 2005, this law was repealed and it was replaced by another law which was called the Right to Information Act, which was passed after Right to Information Bill 2005. And this act has been given an overriding effect on the other acts, including the Official Secret Act 1923. That means even if something is prohibited under the Official Secret Act, still the information can be provided if it is permitted under the Right to Information Act. What was the objective of RTI Act? The objective of RTI Act was fourfold. The first was to empower the citizen. As we know, information is power, and if the citizens have the information, they will be empowered. The second objective of RTI Act is promote transparency and accountability in the working of the government. When a government officer knows that whatever he writes in the file can be known to the common people, he will definitely be more accountable and he will be more transparent while taking decision. He cannot take arbitrary decision because he knows that this information can be sought by anybody, and thereafter his decision can be questioned. It has been able to contain corruption. Earlier, for example, if suppose you give tender to anybody without proper justification, then nobody will know why this tender has been given, why the government has awarded a contract to somebody. But today that is not the case. Any person can get the information and get even the photocopies of the files, and thereafter he knows why particular decision has been taken, and if the decision has not been taken according to the procedures and according to the law, then he can go to the court and get the officer punished for it. So it has been able to contain corruption to a very great extent, and a large number of corruption cases has been brought forth in the public domain thanks to RTI Act. It has also made the Indian democracy work for the people in the real sense, because it is for the first time that the people are feeling empowered over the government officers, because they can get the information and thereafter they can bring that information to the media and the courts, and thereafter they can take action against the government officers. So it has really made the Indian democracy work and more powerful. Now let us understand what is the power of a citizen under the RTI Act. Any citizen of India has been empowered to get the information under the RTI Act. They have been empowered to inspect work, documents, reports held by public authorities, or even information relating to the private authorities under the control of public authorities. They are also entitled to take notes, extracts, certified copies of records and documents, as also obtain information in the form of disk, floppies, or any other electronic mode, or through printouts where such information is stored in a computer or in any other device. So we see that the citizens have full power to get all the information, to inspect these documents and the files and see for themselves why a particular decision has been taken, and then they can take action accordingly if they find anything wrong in that. Now, what is the meaning of information in the RTI Act? The information according to RTI Act means any material in any form which includes records, documents, manuscripts, file or memos, or emails, opinions, advices, press releases, etc. And this also includes the information which is relating to any private body which can be accessed by the public authority under any law for the time being. That means if the public authority before whom you have gone, if they can access some information and they have the access of those information, then you can seek information about that private party also. So can you get all the information under RTI Act? The answer is yes, almost. But there are certain types of information which the RTI Act prohibits or exempt. So those things cannot be obtained, or those agencies cannot be questioned. So first of all, you should know that certain agencies like IB, DRI, NCB, BSF, CRPF, they are excluded from the purview of RTI. That means you cannot go to these agencies and get the information. By law, these agencies, which are basically the intelligence agencies or the paramilitary forces, they have been exempted from the purview of RTI. The second is the information relating to the security, public safety, correspondence with the foreign government, that are also exempted from the purview of RTI Act. Then the third party information, including the commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive position of the third party, that is also prohibited. Now let us say the government is having an access of some trade secret or some of the formulae which has been submitted by the particular business group for copyright or for a patent, and then if somebody asks for that information, you cannot disclose, because that will obviously hurt the business interest of that party, and therefore such type of information has been excluded from the purview of RTI Act. Then the private information which has no connection with the public interest, that is also exempted. So suppose you are a government officer. Now as a government officer, you have a family, you have brother, sister and all those things, and suppose somebody asks the information about the family members, about the government servants, that can be excluded because that's a private information. In the same way, if you have some information about private people due to inquiry or any other reasons, then we can deny that information because that is of no public interest and such information cannot be provided under the RTI Act. Let us now know the procedure for seeking information under RTI Act. So according to the Act, all the government departments have to appoint public information officers. So each state government department, each central government department, they have to appoint a public information officer. A government department's website should normally publish such information so that everybody knows who is the public information officer. Thereafter, the citizen can seek this information in writing and he has to pay the fee, which is said to be very low, that is only ₹10, or in some cases it may be more if more documents are required, and then he can apply to that public information officer for the information. Now the public information officer or PIO is required to provide that information within 30 days. If he fails to provide that information within 30 days, then it is deemed that he has denied that information to the person or the citizen. If suppose the public information officer fails to provide the information within 30 days, or the information which he provides does not satisfy the citizen, then he can file an appeal within 30 days to the appellate authority. Now the appellate authority must dispose the case within 30 days. And if the applicant is still not satisfied, then he has the right to file a second appeal before the Information Commissioner within 90 days. There has been severe penalties which has been imposed under the RTI Act against the officer who refuses to provide the information or provide a false information or wrong information. And the most important thing here is that the penalty which is imposed on the officer cannot be paid by the government department. It has to be recovered from the salary of the individual PIO. And therefore, every officer is scared of this RTI Act, because if the information provided is not correct, or if he fails to provide the information, then the penalty can be imposed and he has to pay from his salary. So friends, today we have learned about the RTI Act, its provision, and how it has benefited the citizens, what are the objectives, what are the procedures of RTI Act, and this RTI Act has been proven to be very useful. Of course, there are negative side of everything, and so there are negative sides of this also. We'll learn that in the next lesson, and please solve those problems which are provided after the end of this particular lesson. Thank you very much for watching the video. Friends, we have learned about the RTI Act. We have learned about the importance of RTI Act, and this RTI Act was implemented in 2005, and now we are in 2018. So last 13 years we have seen the functioning of RTI Act. There has been some achievements, some great points, some highs of the Act, but also there has been some limitations of the Act. So today we are going to learn critically about the positives and negatives of RTI Act, and also we can suggest some solutions as to how we can improve upon the RTI Act. So first of all, let's see the positive side. What are the advantages of RTI Act? RTI Act has indeed empowered the citizens. Now the citizens can go and get the information, and huge number of information has been obtained from the government departments. And there is a very simple procedure for getting the information. Just you have to pay 10 rupee and write a simple letter, no legal complication. That has really helped citizens getting the information. It has reduced the arbitrariness in the decision making. Now the government officers think 10 times before taking an arbitrary decision, because they know that whatever they are writing on the file can be out in the public domain by any time, even after they retire or even after they are transferred. It has indeed checked the corruption to a very great extent. Now the procedures are much better followed, because procedural lapses has been brought forth by the RTI activists, and that has really penalized the officers, and serious action against being taken against the government officers who have violated the procedure or law. Therefore, it has created fear in the mind of government officers for arbitrary decision making, and the decision making has become much more according to the law and procedure after the RTI Act has been brought. However, RTI Act has also been responsible for some of the negative things which has happened in the government. First of all, that there has been a lot of diversion of the scarce government resources for providing the information. You have to understand that the government offices are generally understaffed, because the vacancies are there and the recruitment procedures are complex, and therefore you will find that majority of the government officers are short as far as the staff strength is concerned. Now, when you seek information which require a lot of effort, for example, if you seek information which require collation of information from multiple agencies, multiple departments, then huge amount of resources are wasted in the process, and therefore the efficiency of the government comes down. The second problem which has arisen because of RTI Act is that the officers now are avoiding taking decisions because of the fear of the RTI. You see, in many cases we know, for example, if somebody is a good vendor, somebody is a bad vendor, somebody is a good officer, somebody is a bad officer. This all we know because of the experience, while we may not have documentary evidence for that. But suppose today we take a decision based on our own assessment, based on our own knowledge and intelligence. In that situation, we can be questioned, because unless something is there in the document, we cannot take action against anybody. And therefore, even if you know that somebody is notorious or bad, but unless something wrong is there in file, we cannot take any action against that person. And therefore, the officers are now finding it difficult to take difficult decisions because of the fear of RTI. Then we have also seen that there has been a lot of harassment and blackmailing of the honest and good officers by the RTI activists. What happens that RTI activists practically flood the government office with huge amount of information. So every day they will file one RTI and they will ask for information. And they will ask for very sensitive information, personal information, and thereafter they will try to scandalize the whole thing by printing it in the media as if everything wrong has been done. So suppose they get 10 information, out of that 9 is okay, but 1 there is some problem, they will highlight that and try to project that the officer is a fraud or he is a very corrupt person or he had taken a very wrong decision. So this has really created a fear in the mind of the officers and they really feel harassed many times by the RTI activists. The RTI activists sometimes blackmail them also, that unless you do this, we are going to ask so many information. And I have seen that many times what happens that the tax evaders and all that, many tax evaders try to scare the government department because of RTI and the government officers feel scared of taking action against them. Then because of the RTI, many officers find it very difficult to take action against inefficient and corrupt officers. We have to understand that inefficiency is something which is very difficult to quantify. Because somebody may be working very slowly or he is raising unnecessary objection or creating a hurdle in implementation of the project, it is only a subjective assessment. In the same way, as far as the corrupt officers are concerned, generally nobody comes forward to complain against those corrupt officers. But we know from the behavior, from the market, from our communication with other people, who is good and who is bad. But because of the RTI, suppose you have to transfer an officer whom you believe is a corrupt officer, you cannot do it today because if you transfer him, he can get the information under RTI and ask for the ground of his transfer, and unless you have a documentary evidence, you cannot say why you have transferred him. And these things have been happening quite frequently, and not only the public but also the RTI Act is utilized by the officers and particularly the unscrupulous and the corrupt officer to harass the honest officers. So these are the negative sides of the RTI Act also. Now the question is how we can make RTI Act better. So RTI Act can be improved by taking care of its negative side and focusing on the positive side. So first of all, we should make it a provision that information asked should pertain to the person who is asking the information. The original purpose of the RTI Act was that suppose there is a government department where my work is pending, then I should be able to know why my work is pending. But today, I can ask for the general information. I have seen many RTI activists asking for the information of all the orders which has been issued by a particular person in a particular period of time. And therefore, thousands and thousands of pages has to be photocopied and provided. Now, what is the relevance of that? And therefore, it should be provided that the information should be given only to the person who is concerned with the information. And if the information is in the public interest, then how it is in public interest, that should be very clearly specified, and then it can be decided whether it is really in public interest. And so, unless something is in public interest, nobody should be allowed to call for the information of other people. There should be provision for filing frivolous RTI application. If somebody is filing hundreds and hundreds of RTI applications, then there has to be some action taken against that person. Because so much of government resources and energy is wasted because of his RTI application. And because the penalty has to be paid from the pocket of the information officer, therefore they are scared of not providing the information. And so, if somebody is mischievous, then action should be taken against that person. Then realistic cost of providing the information must be recovered from the applicant. Today, you just pay 10 rupees and you get information, and the cost of providing that information may be running into thousands and thousands of rupees. Now, whose money is this? It is the public money. It is the government money. And therefore, if somebody is seeking that information, he should be charged the realistic cost of getting the information from the government department. Then information should come out with a caveat that this information will not be used for commercial or publicity purpose. Many times this information activists, RTI activists get huge amount of information and then try to make some case or some sensation because of that information. So there should be caveat that this type of information cannot be used for creating sensation, for commercial purpose or for the public purposes. So if we modify or if we do some sort of changes in the RTI Act, then RTI Act's negative point can be taken care of to a great extent, and at the same time we can see that the broad purpose of RTI Act is still satisfied and it can serve the purpose very well. Thank you very much for watching the video. Thank you very much. Friends, we know that Right to Information Act has played a very important role in improving the accountability and bringing transparency in the government. Recently, the Parliament has approved an amendment of the RTI Act which has a lasting consequence on the RTI Act. This has been opposed by many opposition parties and also the activists. So what are those changes which the Parliament has brought? So first of all, in this amendment, the Parliament has given the power to the Union government to fix the tenure, salaries and terms and conditions of service of the Information Commissioners, including the Chief Information Commissioner and the State Information Commissioner. So this has actually created a furore, and this has created an impression that RTI is being weakened. So let us know what changes has been brought in the recent amendment. The first is about the terms of Central Information Commission. The Section 15 of the RTI Act is amended, and the statutory fixed term of 5 years, which was earlier given to CIC, is now replaced with the term to be decided by the government through the rules made under the law. That means now they will not have 5 years of term, but the government is free to decide as to how much term they should have. It also removes the parity between the Information Commissioner and Election Commissioners by having their salaries, allowances and terms and conditions of services. So earlier, the Information Commissioners were at par with the Election Commissioners. Now that parity has gone. But these amendments will be prospective in nature. That means those who have already been appointed, it will not disturb them, but those who will be appointed in future, it will be affecting them. The second important change is in respect of State Information Commissioner. In this case, what has happened is that the Parliament has given the power to Union government to make rules in respect of the matters which are pertaining to the State Information Commissioners as well. So the central government will be able to now make rules in respect of the terms and conditions of not only the Central Information Commissioners but also the State Information Commissioners. So as a result, what has happened is that now Parliament has no power to decide the terms and conditions of the Information Commissioners. It is the Union government which is now going to decide as to what will be the terms and conditions of the Information Commissioner. The third important change which has been made in this bill is that the pension will not be deducted from the salary. Earlier, at the time of appointment of the Central Information Commissioner or Information Commissioner or Information Commissioner of the states, if they are receiving any pension or any other retirement benefits from the previous government service, their salary will be reduced to by amount of equal to pension. That means suppose that your salary in the Information Commissioner is say 2.5 lakhs per month and you are getting a pension of 1 lakh rupees from your previous service, then that will be deducted and you will be getting only 1.5 lakh rupees as salary. Now, the previous government services will include the services under the central government, state government, corporation which are established by central or state law, or the company which are owned or controlled by the central or state government. So from any of these organizations, suppose you are getting pension earlier, then that pension will be reduced. Now this clause has gone. That means you will be getting now full salary and the pension amount will not be adjusted. So as a result of which, what will happen is that now more government officers will be attracted for the Information Commissioner job. So what is the justification of the government? So the government says that the earlier provisions where the Information Commissioners were given the status equal to the election commissioner was not justified because the roles and responsibilities of information commissioner and the election commissioners were very different and they should not have been equated. And therefore, by this amendment, government has only rationalized the two. That means the information commissioner should be brought at a lower level than the election commissioner. However, the opposition is not satisfied and there is a counter view as well. RTI activists and the member of opposition parties, they fear that the amendment is going to have an existential threat to the RTI Act. They believe that now RTI Act will be not effective at all. Two former chief information commissioners have argued that this bill may kill the RTI Act itself because the autonomy of the information commissioner has gone. And they contended that the information commission and the election commissions, these jobs are equivalent and therefore their pay allowances and terms and conditions should have been equal. Now the terms and conditions of the information commissioners has been decided by the government by the notification which was issued in October 2019 and it is effective from October 24, 2019. So the first important change in respect of the terms and condition is that the tenure of the information commissioner or the chief information commissioner, both at the central level as well as at the state level, has been reduced from 5 years to 3 years. The second is that CIC, whose status was earlier equal to the chief election commissioner, it is now reduced to the level of cabinet secretary. And the information commissioner's status has been reduced to the level of secretary. So they have been made at the lower level. Now the information commissioner will be subordinate to the chief information commissioner and he shall be reporting to the chief information commissioner and that is going to lower his position. Earlier they were equal and the chief was only first among the equal, just like it happens in the case of judiciary or the election commission. Another important thing is that according to the Rule 22, the central government has the power to relax the provision of any of the rules in respect of any class or category of persons. Hence, government may invoke these powers to determine different tenure for different commissioners at the time of appointment. So, this particular rule can be misused. Some information commissioners can be appointed for longer term, some information commissioner can be appointed for the shorter term. So, this is another problem with this particular rule. Now, let us know what is the impact of the RTI Act amendments. So, the first important thing you should know is that the public information officer or the appellate authority who are appointed under the RTI Act are basically the officers of the department and they are not very forthcoming in sharing the information because the information pertain to their own department and they will generally avoid giving the information. As a result, the Information Commission was the first authority which was an independent authority and they used to direct these subordinate officers to provide the information. And therefore, whatever critical information was there, it was revealed to the public only on the direction of Information Commissions. Now, according to the recent amendment of the RTI Act, the position of the Information Commissioner has been reduced. Now, Information Commissioner does not have the protection as it was there earlier in respect of Election Commission. Now, they can be removed at any point of time by the Government of India, as a result of which they have lost their autonomy in the sense that they cannot take the decision freely, because if they take a decision which is uncomfortable to the Government of India or any other department, then they can be removed easily. So now they will be very hesitant to take decisions which will be inconvenient to the government or even to the judiciary. So their lower status will now attract a less number of people or less talented people because their status has been lowered now. Another very important thing is that because of the changes in the pension conditions, it will attract more government officers. So now you can expect that in the Information Commission, you will have more and more government officers. And as we know that the government officers are not very proactive in sharing the information. So to that extent, the position of the Information Commissioners will be reduced. So friends, the overall impact or overall impression of the changes which has taken place in the RTI Act is that it is going to weaken the RTI Act. So today we have learned about the different provisions which has been made according to the amendment which has been recently brought under the RTI Act. Thank you very much for watching this lesson.